What is that? Hello and welcome. This is Gray Hughes of Gray Hughes Investigates on YouTube. This channel evaluates all aspects of true crime. As you are aware, videos and live streams in this genre often discuss elements of crime that may be disturbing to some viewers. If necessary, take the precautions needed to avoid these feelings. Factual information related to cases is the key to fostering rational true crime discussions. Fortunately, you will find that here. Please hit the like button only once, share the video, and subscribe if you like my content. Thank you very much for watching. All right. Well, guess what? We got Dr. Colleen Fitzpatrick on again. And wait, let's go to this one. And here she is. How's it going?
Yeah.
Wow, she just did the Spock, live
Sorry,
long.
it's so dark. I feel like there's a face and a big black screen, but I'm sitting. I explained to Gray, I had a tenant and he moved out, a friend that was renting a room. So now I'm down in the kitchen. I'm not, squirreled away in that little cubby hole upstairs where you see me all the time. I'm actually in my kitchen and actually enjoying working from my kitchen table. So sorry, I didn't turn the light on, but it's real bright in the background and it's distracting. Now, I want to say I did promise Gray I could, rotate a little bit so you could see the TV in the background.
Yeah, because my Blazers are playing.
Yeah, there's a game on, and while we're talking,
I was like going like this. Hey, all right.
I can go.
I was waiting for the show. I was waiting for the show.
Down.
Hey, thanks, Karen.
Oh, thanks, Karen. I'm doing fine. How are you, Karen? Where are you located? Where's Karen? Hi, Karen. She gets a hi from me.
Yeah.
Oops, there they go. Yeah, there she is. Where she is. Paulette. Oh, hi, Paulette. I've seen Paulette before. Let's see. Free card. Okay, all cake. I like that. I like cake. I have some.
It's I'll eat cake, but it's sort of like I'll eat cake. I'll eat cake. You know what I mean?
I get it. Okay.
I'll eat cake. Yeah.
I have some muffins in the freezer if everybody wants to come over.
Yeah. So let's see.
We'll watch the game.
Yeah. For those who don't know, if you just randomly happen to be showing up here, Dr. Colleen Fitzpatrick is like pretty much the founder of genetic genealogy for forensic genetic genealogy.
IDM. Yeah, I see everybody.
And she's also the founder of her company, Identifiers International. And that's the company that we support on my channel based on, the ad revenue and the donations that everybody makes. Take a large portion of that. And I think we've given Identifiers close to $100,000.
Thank you, guys.
In the last 5 years. So we've done a lot of different things, got stuff in the works, etc. And that's something the trolls don't tell you about when they're out there trashing my channel. But that is what it is, man. We do a lot of great things over here.
Yeah, Chile, Florida. That's an oxymoron, right? Like military intelligence and.
What'd you say, Chile, Florida?
Yeah, I think that's an oxymoron.
Where's that? Is that somebody's name in there? I don't see it.
No. He says somebody's from Chile, Florida.
Oh,
is that the name of the city, Chile, Florida, or is it a statement about the weather? You have to make things clear. Like you can be from North Pole, Alaska. Why can't you be from Chile, Florida?
Yeah.
Can be confusing.
Well, Dr. Colleen's been coming. Fitzpatrick's been coming on here for years. I think 3,
Yeah.
4, 5. I don't know. Maybe even 5 years. He's been coming on for a little bit.
Before I went gray.
Yeah. It looks a little bit darker than the last time I saw it. You sure you didn't? Yeah.
Oh, it's in the 40s. Oh, how far did the snow make it down to Florida? I'm not in Florida, so I don't know. I'm in California. It didn't make it as far as California.
Yeah. So I was thinking that maybe you could explain before we get into this. Remember a minute ago you were just explaining the free databases. I mean, not the ones that you can upload DNA to that people use for.
Yeah.
Like maybe you can explain those 3 for them.
Okay, guys, the 3 I know about. You ready? Everybody, come on, go ahead.
Get your notes out. Get your notes out.
Everybody got the pencil and paper? I'm watching. Yeah. There are 3. GEDmatch is good old GEDmatch. Now, when you upload, it doesn't do any testing. It's just a database. And when you upload, you have to ask, you have to answer whether you want to opt in to law enforcement use of your match list only, not your data. You can't see the DNA or anything. But will you allow law enforcement to use your list of matches to compare to in case like you pop up or a relative pops up? And that is good for violent offenses. The database can be used, the whole thing can be used for John and Jane Doe cases. So they have probably 1.5 million, something like that in there, 2 million. And then there's Family Tree Database. That company was founded in 2000. In about 2020, oh my God, scandal. They were discovered they had been working with the FBI and letting the FBI use their data. Well, lots of people were upset, but nobody did anything. And they spun it. Now FTDNA has 1.5 or 2 million people. And you have to, well, they may have changed it lately, but until recently, you had to be opted in. You had to let them, or you had to not use their service and bow out. And some people had been there for 20 years, doing their genealogy. So they'd have to take that all away. So they were kind of forced to hang in there. So that's still alive and well. And that is now controlled by Othram. GEDmatch is controlled by Bodhi Cellmark. And then they have MyHeritage, which is based in Tel Aviv, Israel, which is interesting because this kind of recreational DNA testing is illegal in Israel. So bad place to locate a company, a DNA testing company. So it's in Tel Aviv, and they have, GEDmatch has 2 million, Family Tree has about 2 million, let's say, and MyHeritage has maybe 5, 6, 7. However, they are also a testing company, and they have the terms of service that say absolutely no forensics, absolutely. So people use it anyway because they don't check. Now, that gets to be kind of a bit of an uproar, when you have the FBI, involved in big cases. Because the
on MyHeritage, are you able to upload raw data there then? Is that one of the bigger ones that you can actually do?
Yeah. Family Tree and then MyHeritage. And, genealogists can do it, but then in the terms of service, it says, no, don't use it for forensics. No. I think they even call Othram out in particular, but I'm not sure. So you're not supposed to use that. And those of us, who want to go by the rules, we don't use it.
Yeah.
So there you go.
So what we're going to do today is we're going to listen to the portion of the hearing, or the hearing that was yesterday, that was about IgG, and then you can, like when we're listening to it, you can say, oh, this part's kind of weird, or whatever it means, or what their argument, like maybe you can listen to the arguments that maybe Ann Taylor's making, and then when the defense makes theirs, and see what you think is, if it makes sense or not. So whatever comes to your mind. How about that?
Yeah, that's okay. We'll do it that way. Just let it rip.
Okay. Just let it rip, huh? Let me see what happens if I do that one. Is that better? Or I kind of like this one.
Yeah, okay, I like that one too. Let's go.
All right, here we go.
Your Honor, our position is...
Wait, are you ready?
Yeah, yeah.
So I didn't want you to fall asleep right out of the gate.
Yeah, Your Honor, here's my position right here in my kitchen. All right, we're ready.
All right.
That the court should suppress the IgG identification and everything that flows from that. This is supported by Fourth Amendment of the United States Constitution, due process, Article 1, Section 17 of the Idaho Constitution.
I don't know about the Idaho
Your Honor, there was no warrant for several phases of the search that led to, I think, every single one of those stages. A warrant was required. None was given. And so this must be suppressed.
I don't get
Your Honor, I'd like to identify
Keep going.
the 3 stages. And they are when Idaho State DNA sample from labs.
Oh, go ahead.
You know, this is great. I'm having some trouble here because I hear
paused it.
Your Honor, yeah, you know, I'm hearing that and it's not flowing.
Yeah, that's what it sort of. That's what kind of sounded like. That's what it sort of sounded like. Let me think.
Was she really talking like that? Like your like she had something caught in her throat?
I could sort of hear her doing that. No.
It's kind of jerky.
I think I could hear it, but it sounds like have you turned out? Did you move anything on your audio?
Me?
Yeah, you're sort of you're kind of delayed and everything now.
No, I'm hearing.
Have you checked your audio?
Check it for what do you
Because I
want
hear my voice. Yeah.
Jerking or no? I didn't change anything. Okay, freaks, hang on.
Didn't you wear headphones last time? You put earplugs in. I think that makes a difference.
I might be able to find them. I don't know where they are, but I might be able to find them. You think that would help?
I think so. Yeah, you could try it.
You can watch the. Yeah.
Oh, cool.
Wait a minute. Wait. Let me turn the TV on. Is it going to be on TV? You can watch it while I go and get it. Okay, y'all talk among yourselves. Let me go see if I can find my head, which I don't think I can find.
All right. Well, if you don't find it, you don't find it. I don't have she doesn't have satellite TV, and I don't have satellite TV, and nobody's using satellite TV. We're using the internet. So I might have to start over. I could tell that there's some kind of weird. Let's see. Hello. Yeah. I don't know. Maybe if I turn off my background. How about that one? Testing. Hello. That sounds a little bit better. I don't know if you can hear the video, though, when we're playing it. Guess we'll see. I don't know what the audio is. The sound that I keep... You guys hear that in the background sometimes? There's like a little bit of sound. Oh, I hear running.
Here I come, walking down the street. I have like about 5 pairs of these.
Wow.
And I think some of them belong to my iPhone.
Sounds like the monkeys.
Yeah, I think that many of these are not going to work, but I'm going to try just for the freaks. For the good old college try.
Well, do you have speakers, or do you have just the laptop?
I have the laptop. That is it. Have so laptop will travel.
So I think you can just plug it into the audio out and listen, but you can still speak.
I did it, Gray.
You did it?
You there?
You can hear it. Yep. Can you hear us?
I did it. Yeah, I did it. I first try. I found a pair that worked.
Oh, that's crazy.
Okay,
can
is
you
this
hear
better?
Yep, yep.
I can hear you.
I think that's way better. Yeah, whatever you did.
Yeah.
Okay, so now when I play this audio, can you hear it? Listen.
That flows from that. This is supported by Fourth Amendment.
Can you hear that?
Yeah, I can hear, but it stops and it starts. It's
Well, that's because I stopped it. But let me play it again.
No, it's just would you let it run it for 30 seconds?
Okay.
Amendment of the United States Constitution, due process, Article 1, Section 17 of the Idaho Constitution.
Okay, that's fine.
Your Honor, there was no warrant for several phases of the search that led to the IGG work, investigative genetic genealogy. And we think every single one of those stages, a warrant was required, none was given, and so this must be suppressed. Your Honor, I'd like to identify the 3 stages, and they are when Idaho State Police Forensics Lab, through Moscow Police Department, moved a DNA sample to Othram Laboratories to develop a profile to run through genetic genealogy investigations.
So can you think of why they would need a warrant to do that? An unknown DNA sample to bring it
No, wait,
to...
say that. She said they had a, yeah, run that by me. Let me hear exactly. Can you back up and let me hear exactly the way she put that? The wording makes it
Police
different.
Forensics Lab.
Let me go back.
And so this must be suppressed. Your Honor, I'd like to identify the 3 stages, and they are when Idaho State Police Forensics Lab, through Moscow Police Department, moved a DNA sample to Othram Laboratories to develop a profile to run through genetic genealogy investigations. There was no warrant for that search for a SNP profile that could be used to attempt to identify somebody.
Okay.
No, wait, stop. No, that's kind of confusing because she says the first stage was to move the DNA to Othram. You don't need a warrant for that. And now she's saying something about searching for SNPs. She skipped the database. She skipped the upload. She skipped the processing the DNA for SNP testing. She skipped like everything. And then she says, we moved the DNA and you're searching a database for SNPs, or, there's like 50 million things in between there. And she wants a warrant for like moving the DNA from place.
Well, and who do you serve it to, the warrant? I mean, it's an unknown sample. Like, who would you, hey, you're just, I guess she thinks the warrant should go to Othram, right?
No. Whether it's a known or an unknown sample is irrelevant because it's more like what you are looking. A search warrant means you're searching something, like you're searching somebody's house. You don't get a search warrant for somebody you don't know who it is and you don't know what house it is. You have a particular thing that you want to do and you outline it and you say what you're going to do. You're going to search something. That's why it's called a search warrant. It's not called a move the DNA warrant. It's called a search warrant. So that's confusing because she's skipping talking about uploading to any databases. She's just saying move the DNA and do this.
So why would
you don't need it?
Who would you send a warrant to, though? In this case, it doesn't.
No, well, you would send it to GEDmatch, the owners of GEDmatch, or the owners of FTDNA, if that was the way to do it. You serve it to the person or the thing or the organization you want to search. Who's the authority over what you want to search? You have a search warrant for a car. You go and the judge issues a search warrant and the guy goes and searches the car.
So do you think, what she's saying is, do you think that they should have sent a search warrant to Othram Labs before they sent an unknown sample?
No, that's why I'm saying it's so confusing. No, the fact it's unknown is irrelevant. The fact it went to Othram to me is irrelevant. The fact that they sent DNA from the lab to Othram is irrelevant. What's important is the end of that, and they uploaded it and they were searching something. They were searching a database. That's the problem. You're searching something. Of course, you're going to have an unknown. If you do, whether it's known or unknown, it's irrelevant. You want to search something and you got to have permission to do that.
Okay, so when you do GEDmatch, do you have to have permission to do?
No. Like we do. Well, right now, what we do, we just get the snips done, and then we upload it, and it appears in integrated into the database. It's just like Ancestry. You take an Ancestry test. You're an adoptee. You take it. You look at your same thing.
So you don't need. They don't need a warrant though to upload the snips to GEDmatch or
No.
the little sequence or whatever they upload.
No, I think uploading it isn't the problem. It's searching the database. And I think there's been a lot of case studies done on that already. I'm not up to them. I do know, they say things like you need a search warrant but it's almost, I don't think so, because all the people you can see have given their permission to search their results.
But uploading to GEDmatch, that's not considered searching the database?
No, I don't think the actual upload, it's the process after it's uploaded that it goes through the algorithms that integrate that into the database and look for matches. The actual uploading, I don't think.
Okay, so you upload it, right? And then it comes back with centimorgans. People with highest centimorgans, is that considered now searching the database?
Yeah, it's searching who in there do you match.
Right, but you never have to have a warrant when you're looking through GEDmatch, right?
No, we don't. And that's what she's talking about, is actually you need a warrant. And she's citing Idaho state law. Okay. Now, in the Yarborough case, they tried the same thing. They said, wait a minute, you can't do that because Patrick Nicholas, who was the perpetrator in Sarah Yarborough, he has the right. Let's see, that search and seizure is Fourth Amendment because his relatives are in the database and they have his same DNA. He's got a right to say, hey, that's my DNA and I don't want you to search it because all those relatives share DNA with him. And the judge says, no, because they voluntarily allowed that. You don't have standing for somebody else's DNA. It's their DNA. It's not yours, and they gave permission that you can look at it. All they tried that in Sarah Yarborough, and tough luck.
All right, well, here we go. Let's keep going.
The next stage would be when that was transferred to the FBI for their forensic investigative genetic genealogy work to try to identify somebody. No warrant was in place for that work either. Finally, there was a trash pull in Pennsylvania, and there was no warrant for that trash pull either. All three of those stages of this case, there should have been a warrant and there wasn't, and this must be suppressed.
I don't get
Your Honor, for the purposes of the Fourth Amendment protections and article.
Yeah, go ahead. It was totally confusing to me too.
The second one. Now wait, the first one made no sense. The second one was you transferred the information to a genealogist. That's.
Yeah.
So what?
I need a warrant to send it to.
Wait. First of all, the first one was sending the DNA to Othram and searching something, or they stopped. They didn't really.
Oh no! The first one was FBI. The first one was the FBI. They needed a warrant to load it to a database, or not the FBI. You're right. It was Othram first, and then they transferred it to the FBI, and they wanted a warrant for that too.
No,
right?
Yeah,
they wanted a warrant.
No,
they wanted a warrant for when it was transferred from Othram to the FBI. Then they also wanted a warrant to collect the trash. I guess I could see that if it was on the property, but
yeah,
it wasn't.
No, this is all very confusing, and it's like talking to somebody who doesn't quite understand the process, and they pick up every second sentence and they try and make it make sense, or they go to, 3 different references on how this is done, and they put them together into a big patch. And that sounds good, and it's ridiculous to somebody or it's not decipherable to somebody who really knows what they're talking about.
Yeah, well, when we were going over it sounded ludicrous to me. I didn't know what the hell she was talking about.
It's like,
it doesn't match any of the stuff you've been telling us over the years.
Yeah, it doesn't make sense. It doesn't make sense. Is she going to talk more about that?
Yeah, we'll just keep playing it.
Article 1,
Yeah, go
Section
ahead.
17 of the Idaho Constitution, we are looking to see if somebody has a privacy interest that society is ready to support. In this case, if society is not ready to support suppression of every bit of our DNA when the government does not have a warrant and searches it, there is no privacy right left.
Do you have any cases that hold that?
I do not have any cases that hold that, nor do I have any to the contrary that say that's not the case.
I don't get that. She
You're
had
right.
too many
This
negatives in one
is a
sentence. Can you play that
situation
again?
where
Yeah.
is it, there is no privacy right left. Then protections and Article 1, Section 17 of the Idaho Constitution, we are looking to see if somebody has a privacy interest that society is ready to support. In this case, if society is not ready to support suppression of every bit of our DNA when the government does not have a warrant and searches it, there is no privacy right left.
Do you have any cases that hold that?
I do not have any cases that hold that, nor do I have any to the contrary that say that's not the
That
case.
was too much for me. There's too many negatives in one sentence. If she didn't give me that, I wouldn't have known that he hadn't gone there. I can't handle too many negatives. Can you please tell me what they said?
Let me just try it one more time.
Ready to support. In this case, if society is not ready to support suppression of every bit of our DNA when the government does not have a warrant and searches it, there is no privacy right left.
Do you have any cases that hold?
So it's saying, like, you know, if society doesn't want to protect our DNA, then, you know, there's no protections left, basically,
The
like something
government
like
can
that.
come in, roll in, and grab it. I think she's making a drastic overstatement because the people involved have agreed that the government can do that. They don't need a warrant
Yeah.
because they're already fine.
Right, and they uploaded there, and
It's
they
like-
chose
it's
to,
like,
like I chose. Yeah, go ahead.
Okay, suppose they suspected you were a car thief or something, or you committed some crime, and they said, "We're gonna get a search warrant for your car, Gray," and you say, "Oh, okay, just go ahead and search it. No problem. You don't need a search warrant anymore." She's saying, hey, if the people want, I think what she's saying, if people don't speak out, or if she says not actively, you'd say, yeah, go ahead and search my car. It would be different if you're just standing there looking at them, walking over to the car and opening the door, and you never say anything, So it's a little bit too many negatives in the sentence, but I think she's not really on track there because the people involved really did support. They were okay with it.
Right. Like when I'm on GEDmatch, you have to click it for law enforcement use if you want it, and I
Yes.
did that.
Yeah. Are you in GEDmatch?
Yeah, I'm in GEDmatch. Yeah.
Oh, I didn't know that. Hey, were you adopted?
No, but remember I've told the story about how I found my my cousin. Let's see, my
Okay.
mom's sister had a baby that she gave up for adoption, and that showed up first. Like when I was trying to practice how to do genealogy,
Yeah.
and I was being shown, I think Joan Hanlon or something was trying to show me a little bit how to do it.
Yeah.
So I was on there, and I was like digging around, and that was my highest Centimorgan match. I just happened to know that she just came forward to us about 6 months before. So but if I didn't know that, I would have been absolutely lost from the get-go.
Yeah.
Because
Yeah.
I mean, an adopted closest Centimorgan match, and I wouldn't have known who the hell that was. But anyways, let's get back to this.
Okay. Keep going.
Nor do I have any to the contrary that say that's not the case. Your Honor, this is a situation where this identification was done in complete secret behind closed doors, and it's been continued to be a secret. And that should raise red flags for Your Honor about privacy interests that are.
This drove me nuts. It's like, what do you want it to do? Live stream the identification process? I mean, of course you do it behind the scenes, you know?
Yeah. Well, there, like I said earlier, there are certain, well, you don't have to just publish every step, but I think what she's saying is they were doing sneaky things they weren't supposed to be doing, and that's why they weren't saying anything.
Right,
If I have a case, I'm going to GEDmatch, I'm going to, I don't have to tell you that. But evidently there were other databases that were accessed behind the scenes, and that's why nobody wants to talk about it.
Yeah, and they want to have all the information, but in reality, all those people did was provide a lead for investigators to look at and check out. It turns out it was Frank.
And the point is, if the lead is obtained illegally, then you're toast. You can't use that lead. So that's what she's trying to aim at and mess around with, is that all the genealogy that produced this man's name is
but here's the thing, is like, I guess that's the argument, is like, what would make something an illegal lead? I mean, it's just a lead anyways. I mean, no matter what you look at, I mean, psychics give leads. How is that legit? Like,
well, no, I'm saying, the thing is, suppose, okay, I'm not real good at this, but let me guess. Suppose I thought you were a murderer, and the police are all saying, oh, Gray did this crime. If they went to your house and they broke in your house and they looked all over and they found the knife with blood on it and stuff, that would be illegal. Because that was your private property, and they could take the DNA, match it to the database, CODIS, whatever, and they'd have to dismiss that. They couldn't use it because I have I have a real good example. We worked on a case in Arizona. It was Allison Feldman was murdered in 2015 in Scottsdale. And the murder scene was terrible. And the killer tried to clear up with bleach and everything. It was a mess. So and I did the Y-DNA. I'll tell you about that later. Very interesting. But they did familial searching, which is not genealogy. And they came up with a man who was in prison. And he was not the guy, but they had to find his brother, right? His brother, whose name was Ian Mitchum, had been arrested for DUI. And so when they did the DUI, they just took his blood alcohol level and they didn't take the DNA. So the police had a sample of his blood, and they told him that if look, if you don't want us to keep this, tell us within 6 months, we'll get rid of it. He never came back to him. So the police had a vial of his blood, and because of this terrible murder and because of the familial match, they tested it for DNA, and it matched the crime scene. So the man was convicted, he's sent to prison, but then they had an appeal recently saying that blood, it was illegal for you to use that blood because that is not why it was collected. You see what I'm saying? It's not.
Yeah, that's a little weird. But in your original story just a minute ago, you said that there was a lead, and then they told the police and they went into your house and broke in. That's sort of the result of them hearing about the lead. But let's say they heard about the lead and then they behind the scenes looked in to see if this is a viable person, and then they did a warrant. It's just, the lead still got generated originally the same way, and then you're looking,
but to break in your house, even though they know it's you and somebody.
I know, but you wouldn't do that. That part's illegal. It's like
you need a warrant.
But the lead, right? You need a warrant. But the lead that led them to break into your house was still a lead, and they should have done it the right way by having a warrant to go into the house after they investigated you.
You are correct. Yeah, they had. Let's say they don't have let's say this. They're not sure it's you. They have no proof it's you. They know of any but they say, a lot of people say Gray's the guy that stole the money and was running down the street. Okay, they still don't have proof. So what they do is, it's where you get the proof from, or where you get that piece of information that proves it, that leads to the proof. So they can be standing outside the door all day and saying, we think it might be Gray. All these people said he stole the money, but they can't get in the house without a warrant. If they go in the house and they find the bags of money on the table and they're, Nope, can't use that. You can't use the fact
Yeah.
because you didn't have a search warrant. Same way with the blood example. They didn't have a search warrant for that.
Right. But genetic genealogy is what develops the lead. So what makes something illegal to generate just the lead? It's just the lead.
They're right. Right. They are. It's like I get the point, but it's just like breaking your house without your permission. It's like they're saying to go into GEDmatch and upload this and work on it, you need to have permission. Yeah, I get it. I get what you're saying. Because
I see what you're saying too. Like you break into somebody's house, you find a bloody knife, and that's the lead. Oh, okay, and then it leads to this guy, and then you do your original act was something you shouldn't have done. Right?
Yeah, right. Whatever it is, you shouldn't have done it. So no matter what happens before, you shouldn't have done it without asking permission. And so she's saying you need permission to put law enforcement into GEDmatch and search it. That's what she's saying. Now, I disagree with that, but I'm not part of that trial because we do that every day. And the people whose DNA, just their lists that we use, have agreed. In my case, in all my cases, they have agreed. Now, this one, there was a loophole, there was a back door. You have to, manage that. But in the end, it's not illegal, right?
Yeah. No, it's not. I mean, I guess that's what she's trying to say is by doing that backdoor technique or accessing a larger database that they shouldn't have, that the original act of developing the lead is something that is illegal. But it's not. It's against terms of service. It doesn't make it illegal.
Correct. That's a problem. That's a problem because the law. You have the law. You have the law all over the place, and then you have terms of service for a private company. It's not illegal to violate those terms of service. The company might be able to sue somebody saying you caused me damages because you went into my database of my company and you stole all my information on my clients or something. You have to show financial damage, to do, or they could, I think somebody could sue whoever who's doing the loophole. I don't know if they could. I don't know. But the problem is the law is different from terms of service.
All right. Let's keep moving. Let's see what's next. That's interesting. See, I think people find that interesting. Are you gonna pull your hair out?
No, yeah, I am.
The court can see from the various affidavits in this case that there's a lot of things done that don't say how Mr. Kohberger was identified. And the reason for that is because nobody wanted to talk about what happened here with the genetic genealogy. That search was done by making a profile in Othram Lab. That search did not lead anywhere. The FBI took over the search, and from there they did things that we have no idea what it is. That entire segment of this case is secret. We have been through several motions to compel to try to get information, and we've gotten very, very little information. The court should know that we learned today about policies and procedures of Othram that we have not been able to take a look at. Those have not been produced. In fact, we've been told they don't exist.
Okay, you can stop.
We learned about investigative work that was.
All right, let me go ahead.
You see, that's the problem. There is that that the FBI is not being forthcoming. That's creating whether or not you have search and seizure, Fourth Amendment. That's a whole nother discussion we can have. What she's driving at is that whether the FBI uses databases in a way that against the terms of service. Now, Othram is saying apparently Othram did the dance that we all do with GEDmatch. Apparently, she's not saying explicitly, and they didn't find anything. So the FBI did something else, and that distances Othram from any problems here. You don't know. I guess that's the truth. And then the FBI went and did something else. They got profiles that nobody else could get. Now, what did they do? Could be they uploaded to MyHeritage, which is the third database, and it's against the terms of service to use that database for forensics.
Mm-hmm.
So
Not illegal.
Right, it's not illegal, but she's trying, and she's just trying to get the truth to come out. If it's not illegal, why not tell everybody, you know?
I guess what they're trying to do is like, she's trying to, even though it's not illegal, is it still against his Fourth Amendment rights or something?
Yeah, something.
You know, something
and I'm
like
not
that.
an attorney, so I don't know. I can't connect Fourth Amendment to, you know, are you, the way to say it is it violating people's privacy to do that is really what you're saying in a way. Was it wrong for them to compare the killer's DNA to a bunch of people who never agreed to having that done? And that would be my heritage if they use that database.
Mm-hmm.
There's 7 million, 5, 6, 7 million in there. And by comparing the DNA to their, do they have cause to complain that their DNA was used in a criminal case? And they didn't say they could do that.
Yeah. All right, let me play this. Keep going.
We learned about investigative work that was done after Othram had done the work that they could do and before the FBI took over, that we learned about for the first time this week. Not through the motion to compel process. This was a giant secret. When we get to the FBI, we don't know who did the work. You heard that any of that information is redacted. We don't know who did the work. It's a giant secret. And the FBI gets involved. The profile, the text file, that's a snip to use to try to identify somebody is more than twice as big when it gets to the. We don't know how. We don't have any notes. We don't know who did any of the work. We don't have any lab protocols. We don't have any quality assurances. It's not reliable.
You're not asserting that Mr. Kohberger's DNA sample was uploaded into any of those databases, that his own DNA was one that was matched from the crime scene. Not asking whether the crime scene DNA was uploaded, but whether he had, as a, for example, customer of one of these companies, uploaded his DNA.
Well, Your Honor, I don't have.
Are you there?
Yeah, it's
can't
skipping,
tell.
and I'm missing a bunch of stuff. I think
I think your internet.
okay, it
slow
could
or
be.
something, but-
I think and I do have trouble with that sometimes, but I think
Yeah,
what
like right
they're
now you're
saying.
not moving.
Oh, here. Tell me if can you see me move?
Yeah,
No,
you
I
look
moved.
okay now.
Okay.
Yeah, well, what he's bringing up is that, what he was saying was that the DNA, did Kohberger upload DNA and select not for law enforcement use? Because that would kind of seem like that would be a little tricky then, if they somehow went past that and got his DNA when he said it wasn't for law enforcement use. But he doesn't.
Well,
He didn't do that.
I'm saying to me, that would be almost irrelevant, because it doesn't matter whether his DNA is there or not. You can still use a method to identify him. So it is a side issue. And if they went around the terms of service and they're using, he did that, he checked out, don't use my DNA, and they used it anyway. I don't think they did that. They didn't have to do that because they didn't know it was him to begin with. Later on, they may have taken a reference sample. First, you identify Mr. Kohberger, and then you say, oh, it must be him. And you go get a DNA sample and you do CODIS at that point. You don't go back to GEDmatch. You do CODIS at that point. So, comparing, oh my God, they compared his DNA secretly to whatever we have here. How would they know to do that before they actually identified him anyway?
Yeah, I mean, the thing is they didn't know if, let's say he had opted out
Yeah.
And somehow, but his name popped up using the technique, using what was the other one? Family
My
Tree
Heritage.
DNA or the
Yeah, Family
My
Tree.
Heritage. Let's say you uploaded to My Heritage, and that one, I guess nobody can use that. But let's say even on GEDmatch, he had selected out, and GEDmatch, there's that backdoor technique that people were using.
Yeah, the loophole,
And
we know.
the loophole, and then all of a sudden it pops up with his name right at the top of the list. Like, oh my God, it's 100% match. That seems like that would cause a problem.
Yeah, I would say yes, it would. Simply because they're going outside the terms of service. Not that they already knew who he was and they wanted to pin him on him.
Right.
I was testifying in court about that. I was in court and they said, "Did you know Mr. Smith's name before you started?" Same thing. Oh no, I didn't know it. But what are you going to say? Yeah, I knew it was him and I just steered the DNA in that direction. No, I didn't do that. So that would cause a problem, but he would have been identified anyway. It would have been a problem because they violated, but that would not have been the ultimate and only way they would have got to him.
For me, it doesn't even matter. I think it's ridiculous that it matters how just the lead was generated. Like, hey, we think it might be this Kohberger guy. Then law enforcement goes and looks into him, oh, wow, look at that. He was a professor over there at,
right.
Then DNA is left on a knife. He lives there, blah, 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 blah. We know it's the sibling in this one family. And then all of a sudden you collect the DNA and you get the trash from the father's DNA is there.
Yeah.
Now you know that it's him. So you get a warrant and you swab him and it matches the original DNA sample. It's just
Yeah, I mean, there's so much more to it. What they're just trying to do is the root of the poison tree or the poison root of the tree. I forget, but it's like if you generate a lead and you do it in the wrong way, like breaking in the house and finding the bags of money on the table, you can't use that lead and anything else that goes from there.
Yeah. And just a second. Hey, everybody, if you're out there and you want to help support the channel tonight, I would appreciate it with the coffees or super chats, whatever it is. And that's what helps us at the end of the month to be able to afford to give money to places like Identifinders International.
Yeah.
And they do the stuff the right way. So there you go. All right.
We do. We try. It's an uphill battle in a world of evil, but we try.
Yep. Here we go.
So
.com file.
I'm going to keep going.
I don't have.
You're not asserting that fact, correct?
Your Honor, I'm not sure what the court is asking me.
Well, it goes to whether or not your client has standing to complain about the searches of the databases searched.
Are you breaking up again?
Yeah, I am.
Disappears off the screen there for a second.
At best, it was his ancestors.
Well, Your Honor, I am not sure why we're here if the state hasn't alleged
it's frozen.
That
Knife.
Your Honor,
Privacy interest against any of my relatives that might want to upload their DNA to one of those systems. I should be able to stop them from doing that because I share some DNA with them.
That is certainly not what I'm saying. What I am saying, Your Honor, is if somebody takes your DNA and uploads it, I think you have a privacy interest in your own DNA.
But not necessarily in, let's say my DNA is taken lawfully. What privacy interest do I have in the search of the DNA of others?
That's a loaded question.
Why is it a loaded question? Isn't it a factual question?
Well, it is, Judge, but you're assuming that the DNA was taken lawfully, and our position.
I agree that part is an assumption. In my hypothetical, I said my DNA was taken lawfully. why would I have standing to object to the search of other people's DNA simply because I might share some genetic information with them because they are distantly related to me?
Well, Your Honor, our position is that this work was not done lawfully, that it was unlawful, that there needed to be a warrant, that this was done outside of a warrant. And I'm not asserting on behalf of anybody else in this, any relative, anybody who might have been named or not named. This is about an identification process. It needed to be a lawful process. It wasn't a lawful process. It was in violation of Mr. Kohberger's rights. I don't know how he cannot.
How was it in violation of his rights?
Excuse me?
How was it in violation of his rights?
Well, Your Honor, he's been in custody.
You're saying that, I understand your position, which frankly is not well supported in the law, that if hypothetically here, he went to this crime scene, committed these murders, and left DNA on a piece of evidence, that he now has the ability to object to that evidence being searched for identification purposes. There's no case that suggests that concludes that. And it seems to me to be an extreme position to take in light of the case law. And I'm trying to understand how you get there.
Well, I think.
So what do you think? Yeah, he's pretty good. He's pretty good, though.
Yeah.
Right?
Let me tell you, this is the same thing they tried in Sarah Yarborough case. Because first of all, they said he had privacy because he left semen on this girl's body 30 years before. And the opinion was, you got to be kidding me, frankly. You know, the guy abandoned his DNA, semen on this woman 30. So he's got no invasion of privacy. He abandoned it, and we don't know who he was anyway. And then they're going to say, well, he shares DNA with a whole bunch of people in that database. He's got by searching them, you're searching his DNA, and that's not right. That's illegal. And again, they said, you got to be kidding me.
Mm-hmm. The judge seemed like he seemed pretty good. The judge here, actually, those
it's
good
the same
questions.
thing that happened with Sarah Yarborough. No, you can't. Those people said it was fine. It's their DNA, and it's fine. Okay, keep going. Same deal.
Your Honor is asking me about things that I anticipated the state would argue, their abandonment theory, and I would remind the court that the Ross case said that abandonment is a knowing, intentional leaving of something, for one thing. For the other thing, I think that the court is asking me to take a position where it feels like burden shifting to me.
No, I'm trying to understand the legal argument and how this is different from example from latent fingerprints.
Well, Your Honor, I think that things like latent fingerprints and like CODIS, there's statutes about CODIS in Idaho, about what's allowed in CODIS. This is a different search. This isn't an STR search. That's what happens in CODIS. This is a different search.
So I'm going now to, the constitutionality of using the DNA that was allegedly on the knife sheath. And because I understand your argument is twofold. One, your client complains that a search was done of databases of other people to determine whether or not any of them might be related to the person who left the DNA on the knife sheath. That's thing one. Thing two is an objection to the law enforcement searching the DNA by testing it and getting a profile from the knife sheath without a warrant. My question goes to that latter point.
Right.
Understanding the basis for that, because I can't find any case law that would support that idea. That somehow a warrant would be needed.
Yeah, she wants a warrant for testing the unknown DNA on the knife sheath. That's ludicrous to me. That's what she's looking at.
Yeah, that doesn't sound really like that's going to work.
See, that was the whole thing about the unknown sample part. Like, she's literally wanting a warrant to test an unknown sample. Like, that needed a warrant. And then I asked, well, who do you serve that warrant to then? Right?
No, when you say testing let's clarify what we mean by that. If you have DNA laying around somewhere at a crime scene and you bring it to the state lab or you bring it anywhere to get it tested, that's not what that you don't need a warrant to do that.
Right.
What she's saying is, what do you do after that? Do you put it in CODIS? Do you put it in GEDmatch? She's saying in order to search the new database, that's where the warrant comes in. Not testing the DNA. It's putting it in a database and trying to find matches. That's what she's talking about.
Well, the judge is saying something different. Let me play that part.
Two is an objection to the law enforcement searching the DNA by testing it and getting a profile from the knife sheath without a warrant. My question goes to that latter point, understanding the basis for that, because I can't find any case law that would support that idea.
I still think that they're talking about the database. Yeah. Not testing.
And that might even be like CODIS even. I bet it's almost like she thinks there needs to be a warrant to collect the DNA, even to load it into CODIS. Because
well, the judge says, well, what she's saying is that's already been taken care of in Idaho over 30 years. They've always figured that out. She's saying that now this is different because there's nothing there. This is brand new and you just can't walk in and search all these. This kind of I find this all distressing if this is the biggest thing she can come up with, because in other states it's already been resolved that there's no problem, no Fourth Amendment problem with that.
Or DNA left at a crime scene.
Well, I think in our briefing, Your Honor, that we cited the court to some cases.
I did, I think, one concurring opinion in a case that held otherwise.
Your Honor, I was going to talk to the court about third-party data, and I was going to talk to the court about the Davis case that talked about something that the police lawfully had and a subsequent test, the Skinner case, when there's something that's lawfully held, but there's a subsequent test. So those are the things that I want to talk about. Okay. Our first point was an illegal search. And this is if
search, which search?
Assumption.
Which search? It was illegal.
Well, first the snip at Othram, then the snip at the FBI, and then the trash.
So you're talking about the DNA testing of the material left allegedly on the knife sheath.
I'm talking about the Idaho State Police Forensics Lab taking a piece of evidence given to them by Moscow Police Department, collected at the scene, developing a STR profile, uploading it into CODIS, and I think that's the King case. It says that's fine. I know Idaho has statutes on CODIS. Uploading it there and producing nothing. There are no results there. I'm talking about the next set of moves that are super secret that happen when there's a portion of the DNA taken and it's searched by Othram to create a SNP. And then when that doesn't produce anything, the FBI says, okay, here.
Is that even correct?
No. The search by Othram to create a SNP. She's got everything wrong. She doesn't understand what she's talking about. She's not going to win this argument because the judge knows it. He understands the process. You don't search something to find, to develop a profile.
Yeah.
She's confused and it's going to work against her.
Maybe she misspoke. Let's play that part again.
Secret that happen when there's a portion of the DNA taken and it's searched by Othram to create a SNP. And then when that doesn't produce anything, the FBI...
No, Othram just searched it to try to find matches, is what they were trying to do.
Yeah, correct.
Try to build a tree.
She's got it backwards. You don't search and create the SNPs. You create the SNPs and then you search.
Right, and you're looking for matches, and maybe she just misspoke or whatever in that case.
Yeah, keep going. And then the FBI
says, okay, here we go.
Right.
Let's search the SNP ourselves. That's what I'm talking about.
Search the SNP.
Okay. Those are the problems. As far as...
I don't know what that means, search the SNP myself.
Yeah, I think she doesn't... That's a problem with a lot of these, people who They just, it's still, I would say, relatively new, all of this. And she should really she should have gone and taken an ancestry test so she knows how it works. And she, because you did that and you know how it works. Basically, you catching all of this. This is genetic genealogy 101. And she's not even saying.
Well, I know how it works because you've been on the show 1,000 times and you've explained it.
Well, I
so
know.
We all know it. Like all the freaks know it. Like
imagine if you were this attorney. Imagine the resources you have. You have a couple of people sitting there, or who have testified. You have the genetic genealogist coming in. You have people. I think Danny Helwig from IMF, formerly from IMF, testified, et cetera, et cetera. She's surrounded by the world's experts, and she still can't get it right. She can't say it right. This was let me tell the freaks this. Make sure you say things right. I'm a language Nazi. So, when you want to, in an important situation like this man's life is in the balance. You think this woman could say it right. You think she could learn and articulate what she really wants to say. Her client's life is in the balance, and she's in front of a judge who really knows his stuff. I'm concerned for that defendant.
Yeah, not getting a fair representation.
I think that's fair.
Family
Specific DNA tests done of the sample that goes from legitimate to illegitimate?
Yes, Your Honor, I think the Davis case is on point. If the court's theory that this is a lawful piece of evidence taken from the crime scene, the sheath.
Not my theory. I'm just trying to understand your position in light of the case law and in light of the state's arguments. I'm trying to find where the gristle is in this.
I'm adopting the court's hypothesis for this purpose, that the knife sheath was taken. I'm adopting it only for that purpose, and I'm relying on the Davis case that says subsequent searches need a warrant.
And remind me, Davis was the cell phone?
No, Davis was not the cell phone. Davis was blood, a sample with blood. The cell phone case is Carpenter.
To that.
I'm sorry?
Can you give me the side of the Davis case?
I can. Give me 2 seconds. 2 seconds and glasses.
And I apologize because my memory tends to be fact-based and not name-based, and so that's my liability.
Well, it's going to take me just a second. I apologize. I apologize. I wrote the name down, but not the site in my notes, but I know it's cited in our briefing. I can't remember what page. It is 690 F 3rd 226.
Okay. Right.
All right. And so those are the 3 areas that we believe that there should have been a search warrant and there wasn't. There is an expectation of privacy in one's DNA that society is willing to recognize. And I think I'd talked to the court a little bit about the things that happened in this case that were super secret. I think we'd gotten to the point where we were talking, and this goes to recognizing an expectation of privacy when there's all of this secrecy surrounding it. We had gotten to the FBI where the SNP profile was twice as big as that from Othram. And then the FBI went into databases that violate the Department of Justice interim policy. You heard a lot about that Department of Justice interim policy, and that policy it's on page 6 of that particular exhibit that the court has. It says that they're not to go into databases that aren't allowed. And they did that. The court has that in another exhibit.
How's that a constitutional violation?
Your Honor, it goes to privacy.
Don't suppress for contractual violations or even statutory violations.
I'm not suggesting that we do that. I'm suggesting that that's information that's pertinent to this court in making a very important decision as to whether somebody's Fourth Amendment rights were violated, as well as Article 1, Section 17 of the Idaho Constitution. The purpose of offering that information is because there's a policy, so there's a recognized expectation of privacy in what's contained in a SNP. In a SNP at all, there has to be a warrant to search these types of things, and there wasn't. There would be no need to have any policy if nobody cared about this. The court heard about the different IGG databases that changed their rules in terms of use after a different case used IGG.
What did you think about that part she just said? You need a warrant for SNP testing.
Well, yeah, that's a problem. You see, again, she's complicating things. I mean, maybe it's a healthy thing because you have 3 databases and you don't need a warrant for GEDmatch because everybody opted in that you're going to see, hopefully. Now, if they go outside of that and they violate the terms of service, okay, then they have the warrant. But if they only stick to the rules and only have the opted in, they don't need a warrant. Everybody's agreed that they can come and see their list of matches. And really, you are not seeing anybody's DNA in any of this. You are not protecting your DNA. They don't have your DNA. You can't see it. It's deleted from GEDmatch immediately. You upload it. It's encrypted, and you can't reverse engineer it. That's my understanding. So nobody ever sees my DNA. They never see my SNP file. So she's missing the boat there. Now with Family Tree, at that time, everybody's forced to opt in. So just being there, you assume there are some people who died. There's some people whose email was abandoned. I don't know about that. But the point is, the next one, MyHeritage, says absolutely not. You can't use forensics with our database. Okay, so now maybe you do need a search warrant because but again, it's not illegal. It's not illegal. It's against the terms of service. It's not illegal. So the question is the privacy of the people in that database who have not agreed to have their DNA matched against. And again, they're not seeing their DNA. They're just seeing the list of matches.
Right.
And so she's saying, just because you have a SNP, you deserve privacy about your SNPs. Nobody ever sees your SNPs.
That's true. Like you just get the centimorgan count and you start building family trees.
Yeah.
It has nothing to do. Yeah. So your DNA is still private.
Yeah.
That's
your
that
DNA
makes it even more ludicrous. Like it's just a lead.
Yeah.
Guys.
Right. It's getting, she's not, it's just funny money. All these arguments she's throwing out. Like I said, the real argument is the FBI using stuff against the terms of service? What is that? Where does that fit in this big picture? Also, she's saying when the FBI got the SNP file, it becomes twice as big as when it was at Othram. I don't know how you can do that. When you do your SNPs, if they did whole genome sequencing, you have the SNPs. That's it. How are you going to double that? And it doesn't do you any good to have double the SNPs because the people in the database don't have double the SNPs. Right? It's like taking 20 CODIS markers in the lab deciding they're going to make 40 CODIS markers. How are you going to deal with the other 40? The other 20? There's nobody in the database that has them.
Right. You have the specific 20 markers that you use for everybody. It used to be, what was it before, 12 or something?
Yeah, it used to be like 12, I think 12, and then they went up to 20.
That's probably why now they have that math is so crazy. Like when they, because every time it's like a exponential, each of the odds of each of the SNP, it has an odds associated with it. So if you have all 20 of them, you're going to get into the.
Yeah, you keep multiplying because it's all independent, the markers are. So, I'm just saying that doubling the number of SNPs, who cares? And even if Othram for some reason only did half the SNPs, I don't know why they do that, but the FBI, so they double the amount. They still need the people in the database to have those SNPs to compare it against. So what's the problem? You know, and you never see, anybody never sees anybody's DNA in all of this.
Yeah. See, that's the whole thing, right? I mean, isn't that really what matters, everybody? That nobody else sees anybody's DNA at all, ever, in this whole process.
Correct.
It's just that you're finding relatives to the sample DNA, and then you actually do a one-to-one DNA test with that person and the original sample.
Yeah. Yeah.
I mean, it just seems to me like nobody's privacy is being violated. Why is it a violation to say so-and-so's a fourth cousin of somebody else? You know, it's like, I don't know. To me, that doesn't.
Let me just
because
checking
people
with
don't expect to have their DNA
That
searched.
was the point of my question of whether or not Mr. Kohberger's.
Huh? I'm just going to play it. You want to keep listening?
Yeah, I am. I'm just checking
got
in with the
something?
Greeks and seeing if they're all right. Okay, keep going. I think they're all right. I think my chat box kind of got
DNA
spot-
was in any of those databases. There was his DNA and said, I don't want law enforcement to look at it.
Your Honor, I don't think that that's the way the question should be looked at. I think the question should be looked at in the way that we always look at warrantless
I want to see what
searches.
that question was again.
That was the point of my question
Yeah, I didn't get
about
the
whether or not
question.
Mr. Kohberger's DNA was in said, I don't want law enforcement to look at it.
Your Honor, I don't think that that's the way the question should be looked at.
I do think it should be looked at like that, because the thing is if that was the case, I think he'd have a little stronger ground of something
What? I don't
odd
get
going on, don't you think? Like
what are
that
they
if
talking
Kohberger's
about?
DNA was part of FBI, huh?
I don't see.
Well, what he's saying, let's say Kohberger had uploaded his DNA to GEDmatch. And well, that's what he's saying, and he didn't want it used for law enforcement use.
Yeah.
You know, that's kind of what he's saying. Trying to, maybe is that, but he doesn't have that. So he's trying to say, well, he didn't upload there. So I don't know. Let's just keep playing it.
I think the question should be looked at in the way that we always look at warrantless searches.
Got to be a standing.
Your Honor, we're here because the state has alleged that a single piece of evidence ties Mr. Kohberger to this case. They've alleged that there's a knife sheath that has DNA that they allege matches Brian Kohberger. He's now been incarcerated for 2 years, facing capital murder. I'm not sure, unless we're shifting the burden to me, what else I can say.
Well, you have a burden of showing that the items ought to be suppressed.
This is a warrantless search. There's no justification for this search.
Right. Assuming a warrant is required for this type of
there you go.
inquiry.
Well, Your Honor, we think it is. And we think it is based on case law, third-party doctrine case law. That's Carpenter. Thinking about cell phones, that's the Riley case. If you have a cell phone that gets taken at an arrest out of a car, a subsequent warrant to search the cell phone is required. So we think a warrant was required for these subsequent searches. And there was no warrant.
Don't do the cell phone thing on me.
Expectation of.
What's that?
Don't do the cell phone thing, because the cell phone you can take the cell phone, but the contents of the cell phone are all your personal stuff. You do need a search warrant. For GEDmatch, everybody agrees. Hey, use my DNA. Now, my heritage is the question. Nobody agreed to that. But the whole cell phone analogy is just not right.
Mm-hmm. And also, you're not even getting the pupil's DNA in my heritage. You're just getting possible, like this guy might be a cousin, or
Yeah.
I struggle with I struggle, to be frank, and where you're going to have to try to convince me, I guess, is I struggle with the idea that DNA left at a crime scene, that there's any expectation of privacy by someone who leaves DNA at a crime scene that DNA can't be, as you say, searched without a warrant to establish identity?
Well, Your Honor, I don't think any of us can go out of our houses without leaving DNA all over the place.
Not go to a crime scene.
The question of how something gets somewhere, that's the subject of the trial. I think the Carpenter case is really instructive for the court here, and that case was about, it was about third party with cell towers. And there was a concurring opinion in that case. I think that's instructive. We leave DNA everywhere. If you carry a cell phone and it uses the towers, there can be a trail of where you went.
Everywhere?
I'm sorry?
Don't we leave fingerprints everywhere?
We do leave fingerprints everywhere, but I would say, Your Honor, that things like your movements, cell towers, the contents of your cell phone, those are really personal things. That's how you carry out your business. That's how you go. You drive your car to go to the doctor. Your cell phone's hitting on those towers. DNA is even more personal than that. The tests are so different than they used to be now. It can pick up all kinds of information. It takes very little DNA. DNA lives on surfaces a lot longer than fingerprints live on surfaces. So without more, they're not much of an indication of anything. There's a warrant requirement to protect people from unreasonable searches. And that's what we're asserting here. There's so much information contained in your DNA, and you can't stop from shedding that when you go out of your house. None of us can. To be able to have that searched without a warrant could put anybody in jeopardy. There's no privacy left if that's going to be the standard. You put it in.
They're not getting, no, stop. Yeah, but they're not seeing the DNA. Nobody sees your DNA. There's so much information in your DNA. I could care less. I could care less if you have a gene for diabetes or gray hair or blue hair or brown eyes. I don't care. I just want to see your list of DNA cousins. Now, who you are related to is not private, not necessarily private. All I'm seeing is who you're related to. That's it. I'm not seeing anything to do with your medical condition, your phenotype, how you look, nothing. I'm just
she's making it sound like it's just random DNA out there. Oh my God. I mean, there is DNA all over the place, but not on a knife sheath, on a button of a knife on a bed of two people that were killed when they were all killed.
Yeah. Yeah. She's not going to win the argument. She's heading. I don't think this judge has made a decision. I think he's going to make it probably early in the week or something.
Yeah. I can't imagine them throwing this out.
Yeah.
That would erode the Fourth Amendment.
He knows how important it is, actually.
Yeah. Right.
Our position is that there is an expectation of privacy that society is willing to accept. Our position is that there's case law that supports this. Maybe not exactly directly on point, but the court talked about one of the cases that we cited that's similar. It's out of Washington. In that case, it keyed on whether the database was a voluntary, law enforcement can search this or not. In this situation, that's not the case. From the exhibit you have and from the testimony that you heard that the FBI went into two databases that they weren't permitted to search. So if the court wants to go clear to that extreme, and the court shouldn't, the court should look at the Fourth Amendment. The court should look at expectation of privacy. The court should look at the three places there was a warrant required and it wasn't given. But if the court wants to go all the way down to whether or not there was a database searched where the people consented to have their DNA searched, our case is different. The FBI went into two other databases and searched those. There was nothing else happening until that happened. And it's instructive, I think, and important for the court to think about how secretive.
It's like they think, man, our guy would have got away with it had they not got that lead. That's really what she's saying. So she's angry that
Yeah. See, she's wasting a lot of time getting to the point that the FBI searched 2 databases that were against the terms of service. That is the core of the argument here. It's not that, oh, everybody, oh, your DNA's out there. It shows so much about you. No. She took, what is this, 45 minutes to get to the point that they searched databases they weren't supposed to. That's the core of the argument. Now, why is she kind of wandering around in DNA land here? Why is she saying, hey, they did a SNP profile. Wait, they tested it so they searched it to make a SNP profile. Why is she dragging us through? I don't get it.
Yeah. There we go.
This all was. We are months from trial, and we are learning things about how the government identified Brian today in open court when we've asked for those things. There's a reason why there's so much secrecy. That's because there's a violation of privacy rights. That's why there's so much secrecy. Your Honor, this is an extremely.
So what are you saying?
I'm saying
that's probably why they're secret.
I'm just saying that's the question. She finally has nailed the question. You go into a database that's off limits. Is that violating the people's privacy? That is the question.
Yeah, and is it violating their privacy if you're not actually getting the DNA?
Yeah.
From them, or is it just saying who's a relative of somebody? Is that really violating their privacy? I don't know.
Yeah. Well, it's sort of like what is privacy? You have your list of matches. She's got the point, I think, is that this should be off limits. That's the terms of service. For whatever reason, it's off limits. It doesn't matter if the people in a database have put funny names and walk around in funny costumes. The database is off limit, independent of what it is. Right. And that's the core of the argument. It doesn't matter if it's DNA, it's, the list of people belong to the Freemasons. It's off limits. So if you had, let's say you have a club of people and it's private donors or whatever. And the rule is, it's private for legal reasons, whatever, the FBI or the law enforcement needs a search warrant and they need to go into that. Now, so it's the same thing. Is this database is off limits? Did they need to get a search warrant to look independent of what's in that database? It's the company says you can't use my database. And the FBI used it anyway. Is that a violation of privacy of the people in the database? And it depends too. The company may have told the people in the database, hey, we're going to keep your DNA very secure and we're not going to let anybody use it. That's how we build our business because we're going to make these guarantees. And then the FBI rolls in and violates that. So in that case, the company would have some financial repercussions because maybe all the people in the database would split, say, oh my God, they're not protected. That's the question. The FBI did not obey the terms of service. Where does that fall in the Fourth Amendment argument? Where does it fall?
Right.
Is it really a violation of privacy or not?
What they're arguing is it's a violation of Kohberger's privacy, not those other people. So that's what's sort of strange. It's like, this is against Kohberger's Fourth Amendment right. Well, how is it against his right if he's not in that database with those people?
Yeah.
See, that's kind of what the judge's point was a minute ago, right? So, I mean, that is still interesting, right? Because are you violating people's rights to get the lead, and is that something that's illegal?
Well, I think it's I kind of don't know. I'm trying to follow some of this. It's hard because the FBI used the database, right? They shouldn't have done that. Now, I think the argument is they got the data illegally. In other words, the FBI used that, and she says something. It was illegal to use that to generate the investigative lead. I think that's the core. they did something not right, and they got Brian Kohberger. They hear the FBI is doing something, they do something that's not right, and here's Brian Kohberger comes out of that. She's arguing that you got to throw all that out because it was.
Couldn't you just redo? I mean, like, I guess from a forbidden tree, but it's just sort of like, it's weird because you could just do DNA again, and if it leads to Kohberger, it's not like you're finding Kohberger; it still leads to Kohberger.
Let me say this: I mentioned the Arizona case with the blood alcohol level, and the police still had the blood, and the guy never came back to ask him to get rid of it, right? So they tested it for DNA, so he got convicted. So then on appeal, they said, you should have had a search warrant to get that blood and do the DNA on the blood. And the court said something just like you said, well, we can do it again. Let's go get another sample, and showed it was him. It was going to happen anyway. So I think the appeal was denied on the same basis. Hey, so, it was going to happen anyway. We'll go get another sample if you want. Go ahead, waste our time. It's going to be him.
Yeah, and the thing is it is going to be him. And you know why? How you know that is because when they swabbed Kohberger's mouth, it matched the knife sheath DNA in the octillion range.
Yeah, right.
So it's like it's him, right? So the lead was real.
Yeah.
Now, I can't imagine the judge. He does get kind of tough on the prosecutors here in a minute, too. So it's like, okay, I mean, I think he's going to think about it, but he'll be establishing like a precedence by.
Yeah. Now I'll say one thing that I'm kind of surprised at and maybe it's a stupid point, but a lot of the arguments in DNA these days are more situational. How did the DNA get there? Because if somebody gets murdered and the police suspect I did it, and they look, they swab my clothes and that person's DNA is on my clothes, I might not be guilty. I may have seen that person at a party and accidentally brushed up against him.
Yeah, except in this case, you got DNA on the buckle of a knife sheath and a white Elantra driving around outside that matches his. So it's like there's really no chance.
I know, but the DNA is what nails him. And
so, the DNA is huge, but I think even without the DNA, there's a lot of really good circumstantial evidence. But that's what really places him inside.
Correct.
The house itself.
So the DNA is the most important piece of evidence. So I'm surprised that they don't try and dethrone that by situational, it got there and making up another story. Now, the fact they aren't doing that tells me they don't have
they do. Well, I think they know. The thing is the white Elantra, I have the surveillance footage where it's driving around, and then at 4:08 it parked, because at 4:20 it leaves the area. So that means there's a 12-minute window where this white Elantra is right at the house.
Yeah.
Now did Kohberger go into the house? I mean, I don't have footage of him going in there. But in that 12-minute period is when all 4 of the victims were killed, and then inside one of the rooms was a knife sheath, by the way, that he ordered on Amazon, or one just like it. And it had a DNA on the buckle of a knife sheath. So, and it's his. And when they found that, it matched him, and everything matches. So it is a big deal, but at the same time, it's like,
Yeah.
What else is he doing in those 12 minutes with his car driving around? Yeah.
Yeah, you're right. I mean, I got your drift there. And right now we're arguing over DNA. That is the whole video here. So that's what I brought up. There's tons of other stuff we can discuss, but the whole conversation here has to do with DNA.
No, yeah, I know what you're saying. It's just I'm trying to, from the whole perspective, saying there's a lot of circumstantial evidence that would then make it sort of unreasonable to believe that the DNA got in there some other way.
Yeah.
You know what I mean, like just some random, this other guy had a killer and he ran into Kohberger earlier, and Kohberger just happened to be a stalker that night looking through the window. I don't know.
Yeah.
Crazy. Anyways.
Important motion, and the court is going to decide whether we do have any expectation of privacy left or not. The IGG evidence in this case should absolutely be suppressed.
I suspect the state's going to raise an issue that you may need to respond to, but I'll let you respond to that if they do raise that issue.
I'll be prepared, Your Honor. Thank you.
Thank you, Your Honor.
Or should I permit evidence obtained potentially by searching databases that by its own policy, law enforcement said they wouldn't search?
So a couple points on that.
Right out the bat,
First,
right? Yeah.
even assuming,
I mean, that was it, right? Like right out of the gate, he asked that's the question, right? That's what everybody's wondering about.
Yeah, please. Thank you. Finally.
Right. I mean, that's kind of what he wanted her to say like 100 times.
that that's all correct and that they violated the terms.
Seems to be the evidence.
The terms of service, Your Honor, don't affect the Fourth Amendment. The terms of service, and certainly Mr. Kohberger does not have standing to raise a violation of the terms of service. And even if he did, the remedy for the terms of service is not a violation of the Fourth Amendment. As we argued in our brief, the individuals, and as came out in testimony today, the individuals who are utilizing these databases, and we're talking about millions of them, are willingly sharing their information with each other, with millions of other people.
Isn't there a subset that says, but I don't want these people to look at it?
In some of the data,
The FBI is understanding the evidence, then says, okay, we agree, we won't search those ones.
so I'll address that part, but on the database piece, the issue is that no one sharing this information with millions of other people could have a reasonable expectation of privacy. The test for that isn't, do they have a reasonable expectation of privacy against law enforcement? It's against the public writ large. So for example, we cited in our brief 3 different cases where Idaho's appellate courts have found people have given up a reasonable expectation of privacy in information that was shared with a single company. And it was shared with that company just so they could get the service from that company. Here, we're talking about people sharing it not just with the company, but with millions of other people, because sharing it is the purpose of providing it to the database. So regardless of what the FBI did or didn't do in terms of violating the terms of service, no one has a reasonable expectation.
Is it different if they share it with the company and it's obtained by lawful process from that company versus going in the back window and taking it?
No, Your Honor, because right now what we're asking is not reasonableness of the search. Right now what we're asking is there even a reasonable expectation of privacy? And so the fact that no one has a reasonable expectation of privacy in those databases means that even if the FBI violated those terms of service, no one has a Fourth Amendment right to complain. And certainly Mr. Kohberger doesn't. He has not asserted factually or through evidence that he was a customer to one of these databases. And maybe that changes the case if he were, but he's not. He's not even claiming that. He's not even asserting it. Now, I do want to address the second part of the court's question about the FBI has indicated that they wouldn't do this. I believe that's a reference to the policy we've been discussing, the interim policy by the DOJ. I certainly do not speak for the Department of Justice. I do not work for the FBI. I'm speaking for the state of Idaho, but I can read a document. And if you look at the policy in footnote 1, it clearly says this interim policy does not impose any legal limitations on otherwise lawful investigative or prosecutorial activities or techniques utilized by the Department of Justice, or limit the prerogatives, choices, or decisions available to or made by the department in its discretion. In other words, their first problem is they're relying on a policy at all. The U.S. Supreme Court has said policies do not equal Fourth Amendment violations. Their second problem is it's a circular argument. The policy doesn't say you cannot do any of these things. It's saying best case scenario, you're not going to do these things.
Well, if you were interpreting this as a matter of contract, wouldn't you have a problem in the sense that on the one hand it says don't do this, and on the other hand you've got a more general sort of catch-all that says, but we're not really meaning anything we say?
No, I don't think there's a problem interpreting that at all. I think the problem is they are putting way too much weight on this policy as if it's somehow the law, and it's not. It's indicating, and we heard testimony today about best practices and what those mean. This is indicating best practices, but very clearly stating we are not limiting the Department of Justice to have to follow what's in this document as long as it's not limited by the law. And they're trying to use a violation of this policy or an alleged violation of this policy to say that they violated the law. It's circular reasoning. But despite all of that, the U.S. Supreme Court has said a policy violation isn't sufficient. Even the Department of Justice, as powerful as they are, they don't get to rewrite the Fourth Amendment by changing this policy. Now, I do want to address the defense is they're trying to pick and choose what they believe the searches are throughout this chain. And what they're leaving out repeatedly is where this DNA started. Where did the chain start? Well, it started at a quadruple homicide, at a crime scene. There is no case law anywhere that the state could find, and the defense has not cited any to suggest that there is a reasonable expectation of privacy in DNA found at a crime scene. And I want to talk about the Davis case, Your Honor, because it actually cuts against the defense. Davis is the case where it was a very unique set of facts. There was an investigation into a shooting. An officer went to the hospital, and when he went into the victim's room, he saw a bag of clothing. He seized that clothing under the plain view exception to the warrant requirement. So the clothing wasn't abandoned. This was an exception to the warrant requirement. Later on, this individual who was a victim now becomes a suspect, and they have this DNA and they test it. And the Fourth Circuit said, no, you can't do that. You can't take it because he's a victim and then later use it against him as a suspect. That is nothing at all like what we have here. And in fact, if this court looks at the district court opinion that was affirmed by the Fourth Circuit, it expressly states nothing about this holding is indicating that the government needs to get a search warrant for crime scene DNA. That does not support their position.
Who would you give it to?
The Achilles heel in their entire chain argument here is that there is no case anywhere that suggests that a DNA analysis restores a reasonable expectation of privacy. So in the Davis case, no one lost their reasonable expectation of privacy. It was seized pursuant to.
So, I mean, he actually is talking about like.
Yeah. Stop a minute.
For collecting the DNA. I mean, that's why.
Let me look, guys. Let me say this one thing that is not explicitly said, but I think it's right. Is that they say people put their DNA in these databases to publicly search them. You know, like I'm a genealogist. I want to see if you're my cousin. Nah. I put my DNA out there to see that if we match. The police are not restricted to what the public can do. In other words, if the public does it, the police can do it. So, legally, lawfully. So if I put my DNA and I'm a genealogist and I want to find my cousins and I want to find matches, let's say, actually, legally, the police can do the same thing. They can use DNA and they can find matches. You can't limit the police's rights if the public has those rights. The police have them too. Got that? But lawful. You can't just break in somebody's house and rob them. Okay, the police can't do that because that's not lawful. But if you invite a friend to your house, you can, or if you get the idea.
I guess what's sort of interesting is like on that, what's the third one that has 5 million people that they.
MyHeritage.
So on MyHeritage.
Yeah.
Like the public can use it. So the FBI could use it, but you can't use it for what they were doing it for. I mean, what does MyHeritage say you can't do? I guess what is
you can't upload. You can't use it for forensic purposes. I don't know the exact wording, but it's off limits to law enforcement in any forensic cases.
Okay, so but if you had your own zip file, raw data from 23andMe or Ancestry, you could upload it there and just be like, hey, I find some more cousins or something.
Yeah. So the law can do that. Now the sort of blockage there is the terms of service. Now do the terms of service take away the rights of law enforcement? He's saying no, because the terms of service is just a policy. He said the Supreme Court says, I forget the wording, but the policy is violation of policy is not the violation of the Fourth Amendment. Violation of policy is not a violation of the Constitution. You know, it's just policy. So you can't,
Right.
what they say
And
about the interim guidelines is that the interim I didn't quite follow a lot of that, but the interim guidelines are just that. They do say in there that whatever this is, we're not reducing the right of the law enforcement Department of Justice to do their job. These are guidelines. This is policy. Policy doesn't eliminate, change the law. Policy doesn't, you know, is not the end all. Policy is just policy.
Yeah.
And the Supreme Court says
And I guess, yeah. So like law enforcement though takes the, like a regular person like us, we get the raw data and upload it, but then law enforcement has to sort of mimic that process by taking the DNA off the knife sheath and creating a sequence. And that's where, like you were saying before, like bioinformatics has the ability to take a sequence and turn it into what would look like a regular raw data file that then law enforcement uploads, and then they get all their matches, right?
Yeah.
Okay.
So, you know, the public can do it. Law enforcement ought to be able to do it. And then, but then there's the policy that you have to look at, you know, if they say no law enforcement. And he just said, the Supreme Court said that policy doesn't change the law. Policy wouldn't, you know, just because you violate policy doesn't mean you violate the Fourth Amendment. So
yeah, I mean, violating policy might get it so you can't use them anymore. Like they'll go, hey, that's an argument you can have with them, but it's not going to. There's no legal ramifications for breaking.
Correct. Right. You don't argue with the Supreme Court. Go argue with the company that made that policy.
Right. Okay. Here we go.
The Plainview Doctrine. The other case that they're relying on is that recent Supreme Court decision from Arizona. They attached it to their reply. That case is similar to Davis in that the DNA was collected from someone who consented to it under a statutory framework because they had to provide 2 vials of blood so it could be tested for alcohol and drugs.
That's what
Again,
I'm talking about.
That case would have come out differently.
Say what?
That's the case in Arizona I worked on that they're talking about with the guy who did a familial search and then his brother turned up and they had the vial of blood because of DUI. They had two of them to test, and I think they tested one. They told him they'd throw the other one out if he came back, or he could have it, and he never came back, and they kept it. So keep going. That's the one I'm talking about earlier.
Right,
keep going.
I'm going to rewind a little bit.
Seized pursuant to the Plainview Doctrine. The other case that they're relying on is that recent Supreme Court decision from Arizona.
That's yours.
They attached it to their reply. That case is similar to Davis in that the DNA was collected from someone who consented to it under a statutory framework because they had to provide 2 vials of blood so it could be tested for alcohol and drugs. Again, that case would have come out differently had the 2 vials of blood been found at a quadruple homicide. That is a pretty big factor in deciding whether or not someone has a reasonable expectation of privacy. In Idaho, while this specific issue has not been addressed by the appellate courts have told us what to look for when you're talking about a reasonable expectation of privacy. And it's things like ownership, possession, control, ability to regulate access. Mr. Kohberger had none of those things with respect to the DNA on the knife sheath. We are talking about not just a crime scene, not just a murder scene. We're talking about a murder scene in a house to which he has asserted no connection whatsoever. 4 victims to which he has asserted no connection whatsoever. We're not just talking about his DNA happened to be found in, a dresser drawer or something. It was found on a knife sheath where 4 people were killed by a knife. This is as crime scene as it gets. And that's where the DNA was found. And they can't cite any case law whatsoever. And so they try and just ignore that and skip over it and say, well, let's just talk about the DNA analysis. The other problem they have, as this court questions indicated, is the analysis that was done in this case, as we heard the evidence today, is not something that revealed a bunch of private medical information. In fact, the defense's own expert, who is engaged in the same kinds of conduct as Othram in terms of developing these SNP profiles, said he had successfully developed hundreds of SNP profiles and never once learned medical information about any of those individuals. He testified that he has never even heard of a forensic investigative genetic genealogy case that was solved using medical information. And in fact, and I wrote this down when I asked him what he would need to do to learn medical information from those SNPs, he said, quote, "It would be a lot of research." So the defense is positing this question of, they're saying the court needs to ask itself, what could law enforcement do with the DNA? And then decide whether or not there's a violation of the Fourth Amendment. But that's not what the U.S. Supreme Court says. In Maryland v. King, they were very clear when it comes to DNA, because the defense there was asserting the same argument. We have DNA can reveal a bunch of private medical information, and the U.S. Supreme Court said, quote, "Even if non-coding alleles could provide some information, they are not in fact tested for that end." So the question under the Fourth Amendment is not what could law enforcement possibly do with this? The question is, what did they do? And in this case, there is no evidence whatsoever that they did anything to find out medical information about Mr. Kohberger. It was all related to ancestry and identity. And as the U.S. Supreme Court said in King, there is no greater privacy interest in DNA than in fingerprints, so long as law enforcement is limiting its activities to identification. And that's what we have in this case, is identification. Now, the other problem that Mr. Kohberger has here is, in my view, at least, he's been a little bit wishy-washy on the DNA on the knife sheath itself. You don't get to claim Fourth Amendment standing and then just say, well, that may be my DNA, but I have no idea how it got there. Again, the Idaho Court of Appeals has held in a couple different cases that if someone, for example, in one of the cases denied the existence of a bag that had been thrown out of the window, and the court said, well, you can't have a reasonable expectation of privacy in a bag that you deny exists. This is a very similar thing. We have a defendant who is trying to get the best of both worlds. He's trying to say, well, it's not my DNA and the state can't prove that, but he's also trying to say that he has Fourth Amendment standing. And that is not how the Fourth Amendment works. Your Honor, I also wanted to respond to an argument that was made in the reply brief, since I didn't get a chance to do it in the briefing. And this has to do with the trash pull in Pennsylvania. I'll just start by saying that the defense has offered no evidence whatsoever that would take the trash pull in this case outside of the Idaho Supreme Court's decisions in Donato and Paluzzi. Paluzzi is very recent, came out in the middle of the briefing, in fact, and rejected the exact arguments that are being pressed by the defense here. Obviously, this court is bound by that reasoning. When the state pointed that out in their response brief, in the reply, the defense made an assertion that this case is different because the documents the state has provided are not clear on where the garbage cans were located, and that maybe the officers went up onto the driveway instead of collecting them from the street.
Trash company collected.
Correct. I'm sorry.
Trouble now.
Trash company collected them on behalf of the officers.
They're getting in trouble now. First, I just want to stop. First of all, he's right. You can't have it both ways. Brian Kohberger can't say, oh, I don't know if it's my DNA. I don't know how the DNA got on there. You know, I don't know if it's mine. At the same time, say, I have standing. It's mine, and therefore privacy has been violated. You can't have it both ways. Either it's
they
yours,
do a lot of that in this case. Tons of that.
I hope the attorney, this is, a hard case to try if you're the defense. Let's put it that way. I think I can say that. So now they're talking about the trash can, I think I heard that they have a video of the trash guys actually,
Right.
So keep going. I know what's coming.
Correct.
Pulled over after they got out of the neighborhood and said, here's what we've got.
Well, I do believe it was prearranged with the FBI for them to do that. But my point is just, I do think it's telling that they didn't provide the court with these documents that they believe are not clear. And I looked them up to make sure that they were. And in fact, there is an FBI report that was disclosed in discovery that details that the garbage cans were at the end of the driveway, at the end of the property. And at the end, it says, see video. And there was a video disclosed in discovery where you can see the officer's body cam as he drives by the house shortly before they look in the garbage cans. And they're in the exact place you would expect garbage cans to be when they're out for collection. So they, of course, have the burden of establishing a search. They haven't presented any evidence to that. It's not sufficient for them to stand up here and say, well, it's just not clear. Which brings me to my final point, and that is Ms. Taylor continues to say there was a lot of secretive stuff happening in this case. That is not sufficient to satisfy their burden that there was a search, that someone had a reasonable expectation of privacy. When you have the burden, you have to present evidence. You don't get to just stand up and say, well, it was very secretive. I will note in this case, as the court may be familiar with it, as it's probably read back through the record, the defense in this case has gotten a lot more information than many defendants in other states who have, where there's been an IGG investigation, because the majority of courts have found this isn't really relevant information. It's just a tip. Now, it is what it is in this case, and we, of course, complied with all the court's orders and provided the information, but there's not a lot of information, not because it's secretive, but because it's just not our case. It's not what we're focused on. It's not the evidence we plan on using at trial. And yes, IGG was used in this case. And yes, it did point to the defendant. But the fact that that happened doesn't mean that there was a violation of the Fourth Amendment. Unless the court has any questions, we'd ask you to deny the motion to suppress.
If the FBI, in fact, violated the Fourth Amendment rights of Mr. Kohberger, you would agree the state is burdened by that?
It's a great way of putting it, Your Honor. Yes, the state would be burdened by that. Yes.
He's warning him, hey, I might find, maybe I will see.
Oh, here she comes again.
I'll start backwards. I will answer the court's question that the court posed to Mr. Nye. The state is burdened by what the FBI did here. Every action the FBI took in here, all of the secret actions that they took, show you that there is an expectation of privacy that society is willing to accept. They didn't want anybody to know what they're doing. It is interesting to hear that discovery requests and motions to compel and orders have been complied with when I've learned at least 3 new things in the course of preparing for this hearing and being at this hearing so far today. That's a surprise to me. So I wanted to say that, and I want to go back to the trash pool. And I want you to know, when you consider this, that that particular area had an ordinance that trash had.
The court reject that argument very recently.
Your Honor, they might have, but that ordinance isn't all. I was starting with the
They
ordinance.
have a policy.
That it has to be collected by a trash collector, that a certain trash collector, and that you have to put your trash out too. In that circumstance, the FBI worked with the trash collector and had them go just to get that trash and then take that trash somewhere else too. And those are some extra actions that the FBI took in this particular case.
How does that change the analysis?
Well, Your Honor, I think that it changes
the expectation of privacy is lost when you put it in the trash can to be taken away, per the Supreme Court's opinion, even if it's a well-regulated neighborhood by ordinance that says when and where you have to put your trash.
Well, Your Honor, I think that there is an expectation of privacy when you have to comply. You have to put your trash out in that particular manner.
What the hell? That doesn't make any sense.
Unless you're saying the Supreme Court was wrong, the Supreme Court was wrong, and you're reserving that for a later higher appellate court, that's fine.
Your Honor, I may not always agree with the Idaho Supreme Court on everything.
But I have to follow what they say.
But I have to make a record when I don't agree.
I appreciate that. I'm just trying to make sure we're talking about the same thing.
And I have to distinguish the case as best I can. as well. And I think it is different when you have the FBI telling the trash man what to do. I'll move on to something else. I want to talk about now where Mr. Nice started that Department of Justice interim policy, and he read you the first footnote, and I would just direct the court to pages 6 and 7 in that, and that is that the FBI is not to search databases that they're not allowed to. In this case, the 2 of the 4 that they did. And the next page talks about the things that have to be kept in case there's a prosecution case. The prosecutor talked to you about, well, this is a tip. This is just a tip. It's like an informant. And it's thought of in this Department of Justice policy as more if they're told to keep things in case there's a prosecution case. And so that should be considered when you're considering the entire picture that we have here in light of the amount of secrecy that happened here. That takes it out of being a tip. It takes it out of being a lead in the case. I would remind the court, I'm sure the court knows pretty well when we're talking about confidential informants and that type of law, you have to have some reliability. And there should be a big question here about how reliable this is, how reliable whatever it was the FBI did to develop this profile with the rest of the secret things that they did in this case and their willingness to violate their own policy. Certainly not suggesting that this court create a new Fourth Amendment right based on violation of Department of Justice policy, but I'm saying you should look at that and consider that when you're thinking about what the FBI did here and how credible this informant was, how credible this lead was in this particular case. That's fair for you to consider just like you would in any other confidential informant type of case. I would like to distinguish what we have here with our subsequent search. I talked a lot about that before. I won't go too far on.
I mean, confidential informant to me is a really pretty good analogy. Like, you know, you don't get to know, like you don't even know who the person was who gave the tip to cops, and they don't ever have to say who they are. Just like in a DNA, you know what I mean?
Yeah, and the fact is, she's saying, oh, the FBI, blah, 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 came up with this lead. Well, the CODIS is what did it. It's not. The FBI may have, oh, they're not telling us how they came up with this lead. Well, they use IGG. We know that, right? So how did they come up with Kohberger, right? How did they do that? I mean, and why does it matter if they, what do they do? Just pull a rabbit out the hat and say, oh, look, take the phone book, open it, and point at a name?
Right.
You know, there was a lot there. And it went in the right direction. They got the CODIS match. So
or you know, forensic genealogy, IGG.
Yeah.
And then later on,
what they
put them in
did. I'll
CODIS.
tell you what they did. Right. I know where you are. I can tell you everything they did. You know, except violating my heritage terms of service. So
so they put Kohberger into CODIS first. They couldn't find him. Then they took the DNA, did rapid French IgG. I even suggested, hey, man, back then I remember saying, hey, how long would it take to do that? And then they actually ended up doing it. They went out and, you know, got the sequence using, you know, breaking terms of service on MyHeritage. And they it came up with a name probably like Kohberger, but they probably knew it was a sibling in this family. And so they found out, it turns out Kohberger was a male. He also had a white Elantra, and he lived in Pullman, Washington. So they probably could rule out.
Is he an only child?
No, he has a sister. So they just were able to easily rule out the sister. Because the sister didn't go to Pullman, Washington, nor had a white Elantra.
Right.
So all it was is, when they tested the DNA, they only found the father's. They found the father of the contributor to the knife sheath in what they found, and the only reason they didn't find Brian's DNA in there is because he was sifting through the trash nightly, placing his garbage into a different bag and then placing it into the neighbor's garbage can. So, but that was enough to get a warrant. So they got a warrant, then they swabbed his cheek, and then compared that directly to the knife sheath sample.
And now somebody's going to argue it's illegal to go search your neighbor's trash, right? Now, Yeah, searching your own. Yeah, you think the guy lives in the house, you're searching. Oh, wait a minute. Let's go search everybody's trash on the block in case he dumped it.
And that's actually a pretty good analogy. What if they had you know what's weird? That's almost exactly the same as if they had, let's say they saw him put the trash over there in the neighbors, and then they waited for them to move it, bless you. They waited for them to move it out to the street and took it. But isn't it violating that person's rights?
Yeah.
Got it.
Yeah. Okay.
That's actually sort of similar to the DNA, using.
Yeah, you can see it coming.
Well, they didn't do that, thankfully, though.
I'm not going to put my trash out anymore. I'm not doing that. No more trash for me. I'm just going to store it in my garage, and you can get a search warrant to come.
Be one of those people that just have, the hoarders.
Yeah.
A second search and a third search if we're just focusing on the 2 SNP files. These are extra searches that happen after the initial search is done and the STR profile is developed, and it goes into the CODIS database. This is completely different, and a SNP is different. You heard a lot of testimony about how this is sort of new and evolving technology, and the standards that apply are catching up, and there's best practices. You heard a lot about that today. So I don't think we can just say, well, if CODIS is fine, this is fine. It's not the same at all. There is a ton of information. It's your whole genome that gets profiled.
Nobody sees it.
Maybe the SNP that uploads into MyHeritage, which it shouldn't have, maybe that SNP doesn't tell you certain things about a health profile, but the potentiality is there in the SNP profile. For $12, you can upload that profile and find out all kinds of personal health information. It's the potentiality of that. And that's the Carpenter case that talked about the potentiality.
Who cares
of
about
that.
the potentiality?
People have an absolute privacy interest in their health matters. Idaho has a couple of different laws on the books. It has the family DNA law on the books. And think about HIPAA. I mean, we all have to sign those forms every time we go to the doctor if we want anything released to our surgeon. Health matters are important.
But what does that have to do with anything?
If you can upload one of these profiles for $12 and find out all kinds of information.
No. Danny, that was Danny Helwig that was testifying earlier in the secret part where he said he had done hundreds of profiles and he's never messed with the medical, and he doesn't know of any cases solved using medical because we don't care. We don't use the medical stuff at all. To my knowledge, I've done hundreds of cases. I've never done the medical stuff.
Yeah. And what does it have to do with, like, how does HIPAA and this stuff that she's talking about have to do with Kohberger? Yeah,
Nothing.
I mean, it's just ridiculous. It's almost like you're just trying to bring up something.
Well, she's trying everything she can. She's trying everything she can.
Whatever sticks. Yeah. Yeah, throwing crap at the wall, waiting for something to stick to it or something.
Yeah, Well, let's say this. Now, I want to say she's trying her best. This is a very difficult case. I'm not, putting her down, insulting her. She's really working hard to try and figure this out. I have to say that. There's some areas I think she should have studied up on. But then again, I'm not the attorney, and I should not criticize somebody who's doing legal work because, So I want to say this is not meant to criticize every point. I'm saying she was not as clear as the prosecution was. Prosecution came through. I get the arguments. Her arguments I don't agree with, but I just want to say she's doing the best job she can.
All right. Got 1 minute and 50 seconds left.
Was that not a Fourth Amendment? That's what that SNP profile can do. And that was done twice without a warrant in this case. And there should have been a warrant. It violates Fourth Amendment rights, Article 1, Section 17 rights, and this must be suppressed.
Thank you. All right, the matter will be taken under advisement. Let's proceed with the Frank's argument on the IGG and the Frank's proffer more generally.
I think they took a break after that. So
yeah, Yeah, I'm telling you, the Franks thing is whether they were deceitful or something. That's pretty serious. I just,
Yeah, well, Franks is something like if
yeah,
was there something in the probable cause that if the truth was put in there, because there's something that's so egregious that the
yeah,
person ruling on it. But see, I thought what was amazing about that, I think what the main part of that was amazing was the person ruling on it wouldn't have given the warrant. And then this judge said, you mean like DNA on a knife sheath where people were killed? I think he goes, I think no matter what else you have out there, that would be enough to get 51, like be enough to get the warrant.
yeah,
Yeah, so that's how that all turned out, was the knife. But then it's like now he's saying, though, in the Frank's portion, how he knows how important that DNA is. So I can't imagine him just being so sort of, breaking ground here and making a decision, throwing out the DNA in a case like this.
yeah. It's not going to do it. It's too it's too, not damning. It's too,
important too.
yeah, it's not even important. It's not even, oh, this is important, let's keep it. It's so it's the center of everything.
Essential is what.
Yeah, it's so central. You can't leave it out. Where it was found, the circumstances, how it got there on the knife. 4 people were killed with a knife, as the prosecution said. It's so central, to the whole everything going on here. So I don't think he's going to throw it out. You can't.
He just, he's being fair by trying to get, even the questions he was asking the prosecutors, and he wants them to know that, hey, the FBI, they did something against service, but there was no precedence at all, no samples to go by that the prosecution, the defense put out that would help him make a decision in their favor. So.
Yeah, it wasn't very helpful. I have to agree with you. And of course, even if they do accept this, keep the DNA and everything, we still have a long way to go. There's more to a lot of it. And this is certainly an important hearing here. And I think the judge is great. I think he's listening to both sides. I think he's asking intelligent questions. And I think he's going to make a fair decision either way.
Well, I'm telling you, what would solve all of this is my idea that I had a while ago, about a few years back when you were on here, is since you're already taking the DNA to put into CODIS, they should also spit into a little thing, send it off, and we pay for it as a society. Make a deal where it's $100 a person, whatever the hell it is. You send it off, and we have every single criminal's sequence in GEDmatch, and it's for law enforcement use only. I mean, like they get to add it to the rest of it.
Yeah,
and you would have millions of people in there, and a huge diversity too, like all of them.
Well, I'll tell you a story. In May, I think it was like May 2012 or 11 or 12, I was, after I did Sarah Yarborough, I was invited to go down to the Irvine Police Department and talk to them about why DNA. And when I went, I made slides that said, how about GEDmatch? And how about, I said, GEDmatch is really small, but the concept's there. How about, like, you could make a GEDmatch based on firemen, police officers, military, DNA analysts, make a GEDmatch just for law enforcement, from law enforcement people. So at first they said, oh, we can't do that. And then Irvine said, oh, wait a minute, maybe start thinking about that. So I went to the next police department I spoke with. I said, no, what about a GEDmatch? What about you all giving your DNA? And they said, well, if we did that, the unions would use that as leverage in contract negotiations. So that if we said, we will give our DNA as long as you give us a raise, basically simplifying the argument. So then I went to another police department and presented the idea. And the police officer said, yeah, well, it wouldn't work because, there's crooked cops too. And, the Golden State Killer was a crooked cop, right? You get it? So, okay, so that went nowhere. That was 2012. I still have the slides that I didn't present it because mainly we just sat around and talked, but I had it ready to go. And that was in 2012. Well, fast forward, 2018, the Golden State Killer got caught. And like 18, 19, I was up here in Orange County at some kind of award ceremony or some kind of thing where they had the Orange County, the Irvine Police Department was involved in the whole case. And they came out and they gave awards to the people who had really caught him in 2018. And there were the detectives. There was two detectives there that were in that meeting with me. And I went up to him and I smiled. I said, "Do you remember the conversation we had?" And he said, "Yes." He said, "I have notes. One of the other detectives wrote down what you said, and they have proof, that I was suggesting that." And that comes in with what you're saying right now. Didn't you say something like?
Yeah, like I think all criminals are already putting it in there, and we have millions of criminals.
Yeah.
They're already in the CODIS. So why not just take the extra step, put them into GEDmatch, and you just use it for the same thing. It comes
I'm
back.
saying just make your own. No, I'm saying make your own GEDmatch.
Yeah, sure. A GEDmatch
it doesn't matter who actually is in there. All it matters is, do you have a cross section of America?
And that's why I think all prisons and all police officers and all, maybe like that would be amazing, because you'd have it in all the states, varying races, et cetera, et cetera, et cetera. It would all be in there.
I know. And everybody's going to argue with you about that. Just like, "Oh, well, you can't have my DNA because you'll find out I have diabetes." It's, there's big arguments, but there are some countries that do that. I forgot. I think Germany has everybody, maybe, I forget, but there's countries that have everybody's DNA. Norway.
I think this thing, it would solve the problem, because there's so many people and it's so diverse.
Yeah.
And then you just keep adding to it every single year when you're arresting people.
Yeah.
You'd have millions and millions of profiles.
Yeah. Well, you got to say CODIS is, a lot of those people are dead. A lot of those people have aged out of the criminal system. So if you have somebody, I'm actually thinking about this recently, say like the age, after age, let's just say 45, serial rapist, sexual assault, he's too old. He gives up. Well, let's say 50. He just gives up. He doesn't chase women. He's no more assaults or anything. Well, his DNA is in CODIS, and it's going to be in CODIS the rest of eternity. Even though he's 50, he doesn't commit any more crimes. He's dead, dies when he's 80 or 90.
It helps for familial stuff. You can do a familial.
Yeah, no, it does not, because if he ages out, let's say he's 50, and his brothers and sisters are in their 50s, they're not going to be. He may have a brother in CODIS. You're right, but if he's in, and those I think are very, very rare. I mean, you have a brother, but if you're 50 and you haven't already had that familial match, you're a serial rapist. You've done 10 rapes, you're 50, you're not going to commit anymore. If you were going to be caught by familial matching, you wouldn't have done 10. Right?
Well, I just mean, like, if you stay in there forever, and then one of your relatives, even if it's like it
has to be an immediate, it has to be a mother, a father. The sibling doesn't often work. The only way you could do it is if your son does something. And then
is that because of the markers? There's so few 20 markers.
It's the way the way it works. Let's put it that way. But that's the way that the Grim Sleeper was caught, and that was the real advent of familial searching, at least in California. California, I think, was the second state to okay that. So the reason they did that was just for the Grim Sleeper, and they did a familial match, and nothing came up. 2 years later, they did it again, and his son was in the database. And they knew it was his son because whoever it was the child of the Grim Sleeper, and the Y DNA matched. So they had to be a son. Yeah.
See, guys, that's why we have Dr. Colleen Fitzpatrick on. What doesn't she know? Come on.
Well, I hope I explained that right. But and I did that. That was one of my first cases with Y DNA, was the Grim Sleeper. The police actually came over to our house, and they, the guy came in, and I heard about you, and I said, okay. And I ran the Grim Sleepers. Why? And I said, African American. And you could see his face change. And then he acted like, oh, okay, whatever. Okay. But I saw his face change, and that the only other, they had a witness, that a victim that survived, and she had been raped. She was on drugs, and she had been shot. And she said he was African American, and they didn't know whether to believe her or not. So the reason, okay, the police officer comes, and I showed him the why. I did whatever I did. And then he came back later in the week. The reason he was coming from Los Angeles, the reason he came was that he was at the Rodney Alcala trial here in Orange County. And he was attending, Rodney Alcala, the dating game killer. He was attending that trial. And on Friday, the air condition broke. So they dismissed everybody for the rest of till the next week. And he came over to our house to do some more Y-DNA. So
Yeah.
a little asterisk in history there, but
yeah, Zozo's question up. I'm just going to tell you, there's a question that said, if there was like an unidentified body, and you used it in, I always forget the name of that, the one that has 5 million again. You broke their terms of service. That isn't breaking their terms of service, right? Because that's not law.
Yeah, yes, it is. It's a forensic case.
It's just forensic cases. Okay.
Yeah.
What about adoption and stuff?
No, you can do that.
That's pretty close, though. I mean, that's like right there.
No, it's genealogical. It's more.
Yeah.
That is not, a violent crime or unidentified human remains. It is unidentified human remains, but they're alive. They're not.
Do you think unidentified human remains should be under the same umbrella? I mean, that's just like,
I agree
with body that. Out there,
I'm not the one. That's why GEDmatch allows the whole database to unidentified human remains cases.
But I could see there being a slippery slope by people saying, well, it's an unidentified body, but it was killed by a serial killer. You know what I mean? Like, so then you're really using it for forensic.
Yeah.
So then you're sort of gonna, sorry, but adoption.
No, adoption it's either alive or it's your grandma got adopted, and you want to find out who she really is.
Hey, Karen wanted me to say something earlier. She said, Dr. Colleen, last week on the 15th was the 47th anniversary of Ted Bundy when he started the killing at the sorority. Can't believe it's been long, she said.
I bet you Ted can't believe it either, wherever he is.
I keep getting Ted Bundy keeps sending me coffees. There's a person that signs it, Ted Bundy. So everyone keeps saying, thanks, Ted Bundy. I mean, it's about the only time in your life you'd say that.
You know what? If I looked in the databases, I bet you I could find several people called Ted Bundy in the United States. That would freak me out. I would be concerned.
Now, would you really want your name to be that? Feel like
I know. You know what? We worked with a detective. His name was Joe D'Angelo. He spelt it different, but that was his name, Joe D'Angelo. D'Angelo, it was, I think, Diangelo or DE. It was different, but it was Joseph D'Angelo was his name, the detective that came up. Can you believe that?
Yeah. That'd be kind of crappy.
Yeah.
Anyways, we've already been on here for how long now?
Oh, I don't know. It just flew by.
2 hours and 16 minutes.
Yeah, it flew by. But I'm going to say everybody good night, freaks, because I got to go eat. I'm going to put a pizza in the oven.
Nice.
Calling my name. Anybody wants to come over from pizza, got to come over in the next half an hour. Or you're not going to get
Ted Bundy. All right, Ted Bundy, get over there.
Yeah. Oh, please don't. Please don't. No. Sorry, Ted, wherever you are. No.
Yeah. All right. Well, hey, thanks for coming on. That was really awesome.
Okay. Yeah,
Thanks
it was awesome. I'll see you
perspective.
freaks later. I'll see you in a couple of weeks. Okay. So you guys be good for Gray. You behave yourself, and you be good. No food fights or anything like that on the chat. Okay. So you be good, and we'll talk soon.
All right. See you later. Have a good one.
Bye. Bye, guys.
I'll just put you back. Yeah, there you go. All right. Well, I guess that's it for the show. All right. So thanks everybody who was out there to help support the channel. Real tough day today, but not all days are the same, I guess. So we got Richard Watts, Karen, Laura, Laura upgraded to Oogla Boogla. All right. Then Vicky White, then Karen, and Allie Cake and News Chaser. And basically without Karen, we would have been 1/8. And then Allie Cake, Leslie Castillo, Luke Stedman, Joseph Brennan, Vicky White gifted a membership, Jeremy Pearson, Be Kind and Mindful, Stage Left Even, and Heidi Girl. And we only had 2 coffees for this tonight's show. Jeez, wild. And that was from, believe it or not, I guess, or Ted Bundy did 2 coffees. And then we also had one from Lisa Valenzuela. All right, you guys, thanks for being here. We'll see you tomorrow. And as I always say, until next time, be safe out there. Yeah, I've been doing this true crime thing for quite a while now. And during this whole time, I have not seen one person that is a crime dissector, thug rejector. I'm a certified human lie detector. Gonna get ya on a stretcher if you try and play me like an old projector. Crime sector is my nectar. Professor Greg is gonna give another lecture. Crime collector, freak connector, and I'm always gonna be a pup protector. Fool deflector, interceptor, and I'm meaner than a spectre with a vector on his spectre with a spectre. Just remember, I'm a temple fucking checker. I have no agenda, I'm no pretender, and I'll serve it to you straight without the blender. And in the end, I'm gonna send ya on a mission to reveal the true offender. Yeah, so I'll just get right back to work. All right, everybody, talk to you later.